Céidigh, you have 8 minutes.
Minister, I very much welcome this bill, and the primary purpose is to transpose in part the 4th EU Money Laundering Directive into national law and to give effect to the recommendation of the Financial Action Force. I have three main points, Minister, I'd ask you and your officials to consider. But in the context of the bill, perhaps it might be a matter which could be returned to at committee stage. Can I ask you, has any consideration been given by your department to the introduction of measures which are broadly termed the Magnitsky Act, if you're familiar with that? It's been introduced into other EU countries, including the UK, Estonia, Lithuania and Latvia. I note that within Section 10 of this bill, it includes the introduction of a designated person to carry out risk assessment to identify and assess the risks of money laundering and terrorist financing involved in carrying out on designated persons' business activities. Minister, what about providing accountability or creating a deterrent to a person who has committed gross violations of human rights? I'd certainly value your thoughts and opinions on that in relation not just financial money laundering but abuse of human rights and the effects that can have in relation to money laundering. For example, it's one thing to create a criminal offence for failing to comply with the regulatory oversight that's envisaged by a designated person under Section 10 risk assessment. It's quite another to consider what actions can be undertaken when risks are identified. For example, how might a minister freeze funds or economic resources held or controlled by a person if the money laundering or terrorist financing is identified by a designated person? What about third parties connected to the activities identified? And part 3 of my question is, how about extending this beyond terrorist financing and money laundering to persons connected with gross human rights violations? As the Minister is no doubt aware, when the Trump administration introduced its Russian sanction regime there recently, it reportedly affected an aluminium plant in Limerick owned by a Russian oligarch that supplies as much as 30% of the European alumina market. Minister, do you believe that Ireland can or should do more in using either money laundering legislation or other forms of legislation to impede those connected to gross human rights violations? Or do you believe that those safeguards are already in place within the current money laundering legislative framework? As you're no doubt aware, the European Parliament, as far back as 2014, passed a resolution seeking for EU ministers to develop an EU-wide regime whereby sanctions could be imposed on human rights violations identified so that their financial assets could also be frozen. The Council of Europe Assembly this month have proposed a motion that calls on, and I quote, all member states of the Council of Europe and the EU to consider enacting legislation on or other legal instrument enabling their governments under the general supervision of Parliament to impose targeted sanctions such as visa bans and accounts freeze on individuals reasonably believed to be personally responsible for serious human rights violations for which they enjoy impunity on political or corrupt grounds. So, Minister, I look forward to your replies, and when appropriate I may come back at committee stage with amendments to the bill that could see some of those recommendations being fulfilled and protection against gross human rights.
Thank you very much, Senator.
Of particular issues regarding sanctions. Of course, the economic sanctions regime in Ireland is based on EU regulations. We work in conjunction with our EU colleagues. We work closely with them. We ensure that any sanctions applied, any sanction regime to which we are associated are based on an EU approach, which are in turn transposed by means of a statutory instrument signed in general by the Minister of Finance and the Minister for the time being for Business, Enterprise and Innovation. Each of those statutory instruments designates a particular entity or group for sanctions and creates an offence of breaching the sanction. Of course, any offence of this nature, like all other offences, is a matter for An Garda Síochána. But we do that in sync with our EU colleagues, and we transpose the sanction or the agreement by way of a domestic statutory instrument here. I want also to acknowledge the role of the Department of Foreign Affairs on this issue, insofar as Foreign Affairs, through the Foreign Affairs Council of Ministers, which meets on a monthly basis, deal with these issues, such as sanctions, on a country-by-country basis, on a month-to-month basis, or 3-monthly, as the case might be. I refer in particular to the current regime of sanctions relating to Russia and its illegal occupation and annexation of Crimea as part of Ukraine. So we don't, as an individual country, as an individual government or state, engage unilaterally in any sanction regime, but we do introduce our own domestic statutory instrument in accordance with what we would agree at European Council basis. I would be happy to engage further with Senator O'Quaja, and if he wishes to make a submission in advance of the next stage of the bill, I would be happy to have a look at the issues as raised. I want to mention a point raised by Senator O'Donnell